Hey guys, Tanner here, outside of the Dabbler Depot studio, actually in my apartment. Coming to you with a slightly different type of episode today. After the court decision on Monday of this week, staying the lottery process, we wanted to speak to some of our friends in the community and get their initial reaction. Today, we're sharing the interviews with 3 different people, each with a slightly different perspective and angle on what's going on with the Office of Cannabis Management. First, we're speaking with Jen Reise of North Star Law Group. You're going to hear a little bit about the background on that lawsuit and what it's been like dealing with the courts through the past week. Then you're going to hear from Leili Fatehi. She has a slightly different perspective, instead saying that the court's action should not have gone through and the lottery should have happened on Tuesday. Finally, we're going to be hearing from Jeff Brinkman of Superior Cannabis. He has the opinion that OCM has made a number of mistakes during this process that should stop the lottery, if not the entire process. Each of them have a slightly different angle on this. We're really excited to be able to share their perspectives with you today. We're going to be back in your feed not on Monday, but the week after, and we'll be breaking down everything that's gone on, both now and in between then. But for now, we wanted to just share with you these 3 different perspectives. We're not doing any editing on them. They're just coming to you straight exactly as the conversations were had. So here is Jen, Leili, and Jeff. All right. Well, I'm sitting here today with Jen Randolph Reise of North Star Law Group. Jen, thanks so much for joining me via Zoom. It's a busy day for sure.
It certainly is. Thanks for having me, Tanner.
Yeah, absolutely. So I really wanted to have you on to hear a little bit more about your perspectives as a lawyer of North Star Law Group, but also just a little bit about working in the industry over the past couple of months. You represent clients that made it through the review process and would have been part of that lottery, but also had many reach out to you that for one reason or another, didn't make that way into the lottery. What has it been like internally, sort of having clients on both sides of this dispute and having to move forward?
This has been such a difficult couple of weeks, I guess it's been hard. We all were waiting since August 12th. That's been hard. Then once these denials came out from OCM, just a week ago today, denying 2/3 of the social equity applicants. It's been a process of trying to sort out what happened. Why did OCM deny people? Could we get our arms around what we were looking at? And then if there was a next step forward. And what became clear is, first of all, that OCM was offering no ability to fix or explain any of these really very small issues that they had identified, or there were ones that I don't even know what was wrong. For instance, one of our named plaintiffs is a veteran who I worked with him on his application. The only deficiency that he got went to his description of his experience. When I read the description that we wrote against the rule, it looks good to me, but OCM sent us a letter that says that he failed that piece of the description and therefore can't be in the lottery. This is a story that I heard more than 40 times this last week from people in our community, Minnesota craft cannabis entrepreneurs, who got these various denials, some of which they could fix in like 5 minutes. Others, they needed more information from OCM if they were going to be able to fix them at all, including for the next round. And it was deeply unfair. I'm a transactional lawyer. I'm not a litigator. And my hope was that we could get OCM to work with us to get a process in place to correct these people who had not been treated fairly, and get them back on track. Instead, OCM accelerated the timing of the lottery to tomorrow at 11, meaning that the only way that we were going to be able to, that anybody was going to be able to get in front of that was by filing a lawsuit. Still, we weren't the first ones to file a lawsuit. I waited until another big firm filed because I don't want to be the one to slow down the lottery. That is not my intent. And I am so excited for all the people who did get the thumbs up from OCM. I just, this process is so deeply flawed that I think had the lottery been run tomorrow, we would still have gotten court challenges from other players saying that it was unfair and OCM should redo it.
Yeah.
So uh, so because OCM has botched this so badly,
Mhm.
these are the actions that we had to take to protect the interests of our plaintiffs and our community and the process.
It definitely makes sense. Yeah, I think a lot of the initial reporting that came out after those notices were sent out Monday night was this is national businesses, national brands trying to game the system. And that first lawsuit that we did see was from a national person trying to come into Minnesota's cannabis industry. North
Agreed.
Star's filing was slightly different. Can you tell me a little bit about what set your suit apart from some of the others?
Yes. So we carefully selected 6 named plaintiffs who are all Minnesota entrepreneurs trying to set up a small business in Minnesota. No straw men, no weird agreements in the back. Um, we, uh, I think they're an excellent cross section of the kind of poor denials that OCM sent out. For instance, I mentioned the veteran with the sufficient experience that they denied for that. Another one of our named plaintiffs is Sam Milstein, who of course has been on your show. Sam was in the awful position of being super excited originally because he applied in the wholesale or in the transport division, and there weren't enough applicants. There were less applicants than spots, and therefore he was going to get it without being subject to a lottery, except that he got denied by OCM for one line item that is an extremely easy fix on his application. And so we had Sam and other people, lots and lots of people asking us to sue OCM to stop the lottery and or get them some relief. So anyway, sorry, you asked how our case was different. Exactly. So I wanted to bring a case that was that did not involve these kind of straw man issues, but instead are 6 legitimate, bona fide Minnesota social equity applicants.
Yeah, no, I really appreciate that. And I think what really makes your filing and your clients unique is that they very clearly are applicants that should have been part of the process, that for one reason or another didn't get their application approved and had no review process other than filing a lawsuit. So can you talk us through a little bit about logistically what happens next, but then also in your own opinion, what do you think should happen next, either out of the courts or out of OCM themselves?
Yes. Okay. So you want to know logistically what happened first?
Yeah. So like what, in short, for people who haven't been to law school, what is
I know.
TRO? They've stopped the lottery, but what does that mean? And then now it's headed to a new court. What makes that one different?
Oh man. Okay. Briefly.
Yeah.
A TRO, a temporary restraining order, is a common thing that happens in litigation when you need to stop something from happening quickly. You know, drilling in a site environmentally, or I don't know, whatever, launching something, some program.
Lottery, if you will.
Yeah. So it was it was the only method in law to stop the lottery quickly.
Okay.
It doesn't rule on the merits of the claim, importantly, right? The judge is making a determination. There's enough here to say, I don't think the lottery should move forward. Instead, we need to take the time to get our arms around what's going on. And that's because we had just asked, we just need an opportunity for appeal and review. And instead, OCM just accelerated the timeline and tried to push this down our throats, right? So for what happened today, The judge heard the consolidated lawsuits. So the first one that we talked about with the out-of-state folks, ours, there was a third one, and there may be a fourth one as well. People, piling on, trying to make sure that
Yeah,
their
that was
clients
interesting having the attorney
are.
join the hearing as we've filed.
Mhm.
We haven't gotten a number yet, but I'm here in
Mhm.
case you want to include it.
I know that was kind of awkward, wasn't it? But I think not unusual in this kind of litigation circumstance. As far as I know, this is not really my purview. I was uh, I was extremely happy to have Courtney Ernston as my law partner this morning, and as we were preparing this lawsuit, she is a dynamite litigator, which we knew when we formed North Star together. I'm on the transactional side. I help people build successful compliant businesses, and she loves to go to court and fight for her clients. And so, anyway, okay, I digress.
So it's cool to see
So,
that team aspect of North Star sort of all come together.
yeah, thanks. And we also have a bunch of other people who have been adding a lot of value behind the scenes as well. Junior folks making things happen, because filing a lawsuit is a lot of work and a lot of time. Um, Another reason that I don't like them. Anyway, so what happened today was at the 9 a.m. hearing, the judge consolidated the lawsuits, which made sense because they were all asking for kind of the same thing. We didn't know that we were part of the consolidated lawsuit. Courtney actually didn't know that she was going to be arguing in front of the judge until 15 minutes before it started.
Okay.
So it's been, it's a dynamic process around here.
Sure.
The judge heard the various parties' arguments and agreed with us that the lottery should not go forward tomorrow. So he paused the lottery and sent the case to the Minnesota Court of Appeals. And that's because of the procedural issues that people probably were confounded by in the discussion. And I don't think you need to try to get your arms around that.
Nah, but in
It's just
short, it now
it's
means
a
that the court
question of which court has the proper jurisdiction to hear this claim,
okay.
Because of its positioning as the decision of an executive agency. So, okay, so theoretically it goes to the Court of Appeals. We don't know a lot about what happens next there, but here's what I want to make sure to say to folks is that the ball is really in OCM's court still. I believe that they still have an opportunity to design a fair process by which people's applications could be corrected, or OCM could say, oh, actually, our bad, which would make this litigation moot, and then we can all move forward. So in a sense, I'm still asking for the same thing from OCM that I was asking them for last week, which is we need a path forward for our clients. We don't want to cause unnecessary delay. We just need to fix this for these people that did not get a fair shot.
Well, I certainly hope OCM figures out some way to move this forward, because I think we're all looking at the courts as a pretty long, dragged out process if totally played out. So having OCM come out and make a decision would definitely be preferred. So just sort of wrapping up today, there's many other people that were denied and are thinking, man, this sort of applies to me as well. Are there still opportunities for people to get involved with lawsuits, get involved with going on in the court? Or at this point, is it sort of our eyes are turned to the court and we're just waiting for them or OCM to make decisions?
So we made sure to include in our lawsuit that we were asking for relief, not just for our 6 named plaintiffs, but for others similarly situated, because we had heard from all these other applicants that they had received the same kind of denial notices. And I didn't have time to get my arms around all that, make sure they were all legit. But I know that there is a lot of other people out there who are similarly situated. And so we made sure that what we were asking for covered them as well. So they do not need to actually join the lawsuit to get the benefit of it at this point. Yeah, because I've gotten a lot of emails asking, oh, can I join the lawsuit? Whatever. No, ship sailed, guys. Sorry.
Okay. Well, hopefully we see some decision out of the court or OCM that for everyone, both the named plaintiffs and otherwise, provides them some sort of path towards securing that application and getting into that first round of the lottery.
Mm-hmm. Mm-hmm.
Well,
Thanks,
Jen,
Tanner.
thanks for taking your time today. I really appreciate it. I'll let you get back to stuff. I know it's a busy day with everything going on, but I appreciate it so much. For people wanting to learn a little bit more about North Star, where can they go to sort of see some of the work that you guys are doing?
That's so fair. Our website is northstarlaw.com /cannabis to go directly to the cannabis part of the firm. You can also call our front desk at 651-330-9678. In addition to filing OCM only when absolutely necessary, suing OCM when absolutely necessary. I actually spend most of my time helping people build successful and compliant businesses in the hemp drive space, and God, I hope so soon in the adult use space.
Yeah, I absolutely hope so soon as well. Mm-hmm. Awesome. Well, thank you so much, Jen. I really appreciate it. Have a great rest of your Monday here.
Thanks. You too, Tanner. Take care.
Awesome, and we're back. So we're sitting here today with Leili Fatehi of Blunt Strategies. Leili, welcome. Thanks for joining us today.
Thank you. Pleasure to join you.
Yeah, we're really excited to dig a little bit more into everything coming out of the courts and OCM. But just first off, what is your initial reactions to the decision out of the courts today to pause that lottery?
I don't think that the judge's reasoning was legally sound. And I want to thank my friend Carol Moss, who's an attorney over at Helmuth and Johnson, for kind of explaining this to me. But you know, when the judge says that the plaintiffs have to go to the Court of Appeals and they need to go that direction of, you know, a writ of cert. Basically, the judge was acknowledging that the district court doesn't have subject matter jurisdiction. So then for that same judge to stay the lottery, my question is, if you don't have subject matter jurisdiction, you don't have subject matter jurisdiction. I don't know that that stay really is legally valid. So I thought the judge's decision was kind of confusing in that way. I was waiting to see if we would get some sort of an emergency appeal from OCM. Still waiting to see if that happens. But yeah.
Interesting. Yeah, it was super interesting to listen to the hearing itself and have much of the discussion not really center around the qualifications of the applicants or maybe what were wrong with the application to the process, but more around, you know, can the judicial branch come in here and tell the executive branch, how do we make—
and this is, yeah, I mean, this is an important conversation for them to be having, because this goes really to what is written in the statute and what was the intent of the legislature and how it wanted the agency to carry out this pre-approval licensing process. And again, people need to remember, this is not general licensing. This is for just license pre-approval, which is something that the legislature passed into law near the end of session with a very explicit mandate that it apply for only the most operationally ready of social equity applicants to just get pre-approved for a license. And as part of that, the legislature was very explicit in the statute that the agency's decisions were final and that there was no appeal, versus with the general round where the legislature did provide for mechanisms for appeal. And so this question of, is there jurisdiction for a court to be hearing an appeal, really goes to the heart of what did the legislature intend? And, you know, they didn't intend for this to be appealable to a district court. This is not the first time that we've had a district court. You know, there was the prior lawsuit that was West King challenging, and you know, the court there said the same thing, that it lacked jurisdiction, that it needed to go to the Court of Appeals. So apparently the district court judge, Judge Smith, today agreed with that. He did not grant the temporary restraining order, because that would have required the plaintiffs to demonstrate that they were more likely than not to be able to prevail. Um, you know, on the merits, and like if there's no subject matter jurisdiction, then they can't prevail. So the judge agreed with that, but then somehow saw fit to stay.
Interesting.
Yeah. Yeah.
So you would look at the decisions that OCM made, and based upon what we know right now, say that that's sort of the true party of interest system working as intended?
I think that there are sort of two buckets of plaintiffs, or it's not even plaintiffs, it's folks that were denied. One is the bucket of people that were violating the true party of interest, the various disclosures, the things that we all know as the advocates who were pushing for this. This was the heart and soul of this Minnesota model and our legislation, was to keep, you know, smooth operators that are really trying to rig our system out. And then there were folks who had errors on their application and were denied on that basis. Again, you know, the pre-approval process was designed for those who are the most operationally ready. And OCM could not have been clearer from the beginning in saying that your ability to navigate the questions and this application process is a proxy for your operational readiness to operate in a highly regulated market right now. So I think, you know, if you're OCM, you have been flooded with these applications, many of which, I mean, the majority of which, you know, is nonsense coming, you know, from out of state and attempts to rig the system. You have to come up with a standard, a black and white standard that you are going to apply for who gets through and who doesn't. And you need to apply that uniformly. And that's what they did. And were there some good faith applicants that, by virtue of having made errors in the completion of their application, were denied? Yes. Is it probably unfair for those individuals to have to, you know, pay the application fee? Yeah, I would say so. But I would say that, you know, the trajectory for getting a just outcome for those individuals is a negotiated fix with the Office of Cannabis Management that, if it's necessary, also includes the legislators, that basically allows those individuals who were good faith actors to be able to do either, you know, a second round of license pre-approvals perhaps, or move to the front of the line and not have to pay the reapplication fee.
Yeah.
This is all in that universe of acceptable outcomes. But what bothers me is that there were 600 applicants who, by virtue of being operationally ready, were able to submit successful applications. And now the rug has been pulled out from under the legs of those 600 local small business owners that passed muster in terms of true party of interest, that passed muster on, you know, all of the other things. And it is to the benefit of not just those folks that were well-meaning and who we perhaps could have come up with other solutions for, but a lot of these other plaintiffs, the majority of these plaintiffs, who are exactly the kind of folks that this statute intended to keep out. And we all worked on it. We know that that's the case. So, you know, I mean, people, I mean, you got to think about sort of the company you're keeping with these plaintiffs. The latest one that was just filed, the plaintiffs include Lucky Ticket Minnesota 1 LLC, Lucky Ticket Minnesota 2 LLC, all the way down to Lucky Ticket Minnesota 25 LLC.
Yeah. Yeah, no, I definitely hear what you're saying. And I think we created a system, the collective we, to try to figure out how do we include people in our lottery, in the license system, in our entire industry that really are the good actors. And it's curious to see how that has played out in excluding some people that very clearly should have been excluded. And then also perhaps excluding some people that maybe are on like the borderline. What might you say to some of the people that would have said, I submitted my application properly, but due to perhaps issues with OCM or otherwise, now I'm out of round one of the lottery.
Yeah, I mean, again, people are not out of round one of a licensing lottery. They are out of a very limited lottery for license pre-approval that, again, was always defined for the most operationally ready social equity applicants. And it was a round that was created by the legislature, the same legislature that can be involved in dictating what the solution is for this population of applicants that they very much intended to ultimately, have a fair chance at a license. And I have seen nothing coming out of OCM that would indicate that this is not an OCM that would be receptive to. And I think even in their early statements, they said we might have another round as soon as early 2025.
Mm-hmm.
I mean, that to me means they can, at their own discretion, open another round and say, okay, those of you that had, errors, now we can put out more guidance and things like that, more technical assistance, and you fix it.
Mm-hmm.
The other thing is, I feel like there's been a little bit of a framing that this is the only social equity round. This isn't even this is a social equity pre-approval round.
Mm-hmm.
There will still be these separate tracks for social equity applicants versus non-social equity applicants when we get to a general round of licensing. Those folks still are going to have that opportunity. There are tons of folks that didn't even apply for social equity verification yet. And our licensing process assumes and has built into it opportunities for them to be able to enter. That's why OCM limited the number of license pre-approvals, even is because they said we want to afford enough slots for social equity applicants who may not be operationally ready now, but they are in 6 months or a year, to still have a bite at that apple. So I think that there's still ample space to work with OCM, and if necessary, also engage legislators. That's what I've done today. I've spent my time talking to legislators, to ensure that everybody is still maintaining a focus on who are the folks that we want licensed and who are the folks that we don't. The thing that I'm a bit disappointed to see is that I think some of the folks that were good faith, applicants really end up arguing in favor of this lottery just being held up, harming the other businesses that really are like them, local small businesses, to buy more time and, quite frankly, to put more money in the pockets of the lawyers that are representing Lucky Ticket Minnesota 1 through 25 and some of these other companies, where the contracts speak for themselves.
Yeah, no, I think that's super fair. And I think it's sort of the value judgment that people are weighing, because we definitely do have people like the applicants that you talk about that are the large multi-licensed applicants that we don't really want to see coming into the state. But I think it's also fair to say that there have been lawsuits filed by Minnesotans who were small business owners or prospective small business owners who, due to no fault of their own, and I don't mean people that submitted incorrect applications or submitted, not enough information, but people that were legitimately sent incorrect links by OCM staff that now are being told, round two. I hear what you're saying, that it's not actually round two, but we created the pre-approval system because we saw value in getting pre-approval. I think it's sort of, sorry, go ahead.
I do think that there are instances, in that instance that you point to with the faulty link. I mean, there are instances, I think, where the agency likely just made an error. I mean, they made an error and that person is entitled to some sort of specific relief. And they could have filed a lawsuit to get that fair relief. That individual is not in the same legal position as somebody that was disqualified because OCM applied a common standard to them.
For sure.
The entire argument, I mean, to me, it seems like it's a separate lawsuit, is a separate set of arguments to be bringing. So I think, I think, what we're seeing is that this kind of thing legally can move through the court system kind of quickly. I'm still interested to see, I mean, given the fact that, um, the judge acknowledged that there is no subject matter jurisdiction at the district court level, what that's going to mean. My team, we are looking into retaining counsel for the 600 applicants who were successful in getting their applications through, because quite frankly, they're the ones with the most specific demonstrable harm that is imminently posed to them by what is going on. If, that license process, if that pre-approval lottery doesn't happen, they're the ones that are going to be denied something that was very explicitly laid out by the legislature, something intended to be a right of theirs. And so, yeah, if anybody that's listening is among those 600, shoot me an email and we will find you a good attorney so we can try to file an emergency appeal.
Okay. Okay. Well, so we've had people mention that perhaps OCM could take action that would sort of sidestep the judicial process and maybe make this court case moot before it even moves forward to the Court of Appeals, perhaps by allowing some sort of review or curing process for people. Do you foresee any action out of OCM that could perhaps nullify a lot of what's happening out of the courts, or what are sort of your thoughts on that based on what we've been hearing?
I don't know. To me, that seems, allowing that kind of appeal process when you have this many denials is as good as just canceling the process, especially since I don't even know that they can do that. It is pretty explicit in the statute that these are non-appealable decisions. It is a non-appealable decision. And I mean, quite frankly, when all of these rejections came out, the first question I had was, well, why did some people get deficiency notices and other people didn't? It was that OCM better have a really clear answer for when they decided to issue a deficiency notice and when they didn't. And they did have a very clear sort of black and white explanation they sent for what a deficiency notice was issued for and what it wasn't. Unfortunately, it meant that those people who made good faith errors in, say, the entry of some information in their application, it meant that they were just summarily denied. But I mean, the definition of something being summarily denied is that there's some basis on which you draw that summary decision, right? And as far as I can tell, with the exception of those instances where it seems like OCM really made an error, in majority of these instances, they applied a uniform standard, and the outcome was disappointing for some folks, who perhaps wish that they had done a better job proofreading, or I don't know.
Yeah, no, I think that's
their applications themselves instead of letting a consultant do it. I don't know.
So where do you think things go from here? I mean, obviously from a logistical standpoint, it's going to the Court of Appeals next. But do you think we'll see an appeal from OCM, or sort of where do you see the next week going?
Like I said, I think that we're likely going to see some sort of legal intervention on behalf of the 600 individuals who would have made it onto a lottery. And OCM has not said that the lottery is permanently canceled. They're just saying that it's not happening tomorrow. And so, I'm sure they are evaluating what their legal options are at this point. I'm not sure exactly what the timeline is for now the plaintiffs to file something with the Court of Appeals. One of the other attorneys mentioned something like 60 days, which obviously would put us, pretty far outside this window. But, yeah, I don't know, it's a tight timeline. OCM, in one of the affidavits that they filed, indicated that this particular date for the lottery had been selected back in September, and that it is going to cost the state in excess of $100,000 of just forfeited fees now that is going to have to cancel it. Yeah, so, these are.
But there were two dates, there was the December, and then now there was the tomorrow or 11/20/60. I mean, so what are you referencing, or what are they referencing?
Yeah, I mean, I don't know, again, it was an affidavit filed for the purposes of a lawsuit. I mean, they may be putting it up there with some bluster for creating urgency, and it may be that they are able to reschedule it. There's still a lot of unknowns, I think, as this makes its way through the system. I mean, again, this is something Carol Moss helped me better understand, was the fact that, the judge first needs to actually issue an order, and there needs to be a judgment attached to that order. Prior to that, there's not really anything legally operative that necessarily, forces OCM's hand to even, and that's why I was saying I don't feel like they even needed to not hold the
Interesting.
lottery. So again, I'm not a practicing attorney by any means, so maybe there would have been additional legal headache for them on the other side of that if they had done that. The AG's office, I'm sure, is being extremely diligent with this.
Right.
Must be challenging for somebody like Carol Moss to have clients on one side and clients on the other side, and having to navigate both as their counsel.
Attorneys have, rules of professional responsibility and, certain ethical obligations that, they exercise in these kinds of instances. So I think for the lawyers, this is probably familiar territory, and they have their means of ensuring that they're navigating it in a way that is both legal and ethical. But yeah, no, I mean, I think it's a challenging situation.
Well, Leili, thank you so much for taking time out of your day to come on to chat with us a little bit about some of the actions out of OCM and the courts, and sharing your perspective on it. I'm really excited to see where everything goes from here.
Yes. Thanks so much for the opportunity.
Awesome. Well, thank you again. Have a good rest of your Monday.
Thank you.
All right, and we're back. So we're sitting here today with Jeff Brinkman of Superior Cannabis. Jeff, thanks so much for joining us virtually today.
Absolutely. Thanks for having me, gentlemen.
Yeah, for sure. Wish you were coming on at better circumstances, for sure. So
I think we all do at this point.
Yeah, absolutely. So just to fill us in a little bit on your thoughts, this morning we had that decision from Judge Smith postponing the lottery that was scheduled for tomorrow. I mean, what were sort of your initial reactions to seeing that decision come out of the court?
I think my reaction before the decision, did you gentlemen listen to it this morning?
I did.
Yeah. It was, I thought the AG's office really came out with some arrogance, and I think the judge caught on to that right away. And I think it actually, with that maybe arrogance, they brought really no defense to the process. And because I don't think there was one. And when you get kind of these, blank denials or even the vague denials, we were talking early on about, several people called me about applications, and, you kind of run, bounce things off of people as you're filling them out because they're extremely complicated, right? And I kept asking, like, well, what's the criteria here? And exactly, what are they looking for? And a lot of people are like, well, we don't really have like the set criteria. It's just kind of a template. And I think if you don't have the, upfront, real clear criteria of what's going to bounce you out or keep you in, it's kind of a shotgun blast into space, right? Like you're trying to catch everything you can. And I'm sure that too also develop some costs for these people because they're having attorneys do it. They're having specialists do these things for them that, without the criteria in front of them. And I really think that made for kind of a chaotic, even application process. And then the denials that came out, what criteria, everyone's like, what criteria and what bounced me out specifically, and they can't answer that. And then there's no review or appeal or anything. And it's really a due process matter for me. I think a lot of legit people that should have been social equity applicants, and I'm a big small business person, I'm a big social equity person, and I just felt like they were set up to fail at the start.
Yeah, there were a couple of things that you said there, but one that stands out to me was you were talking about the defense for the state not really having a ton of actual arguments in favor of why this process was fair, or why it's good to not have a review process, or why they should move forward with a lottery. Most of their time was spent just claiming that the court doesn't have jurisdiction. And there was even that moment where the attorney joked to the judge about, like, I know you don't like hearing this, but this isn't your case to decide. And the judge sort of smiled at that. And it was clear with the decision at the end that the judge disagrees, at least, that they have jurisdiction to put that pause on.
And didn't you think early on, in that, I do think that judge was really on par with what a lot of us were thinking. And he really did just, I mean, this is a fast case, right? Like, this is just like in your face. And, he's trying to sort this out on a very short time period. What was it, less than an hour?
Yeah, absolutely. It started at 9,
and I mean,
I think the decision came in at like 10:30, but that was with all the introductions and the rigmarole of
Yep.
if you will.
Yeah, like, why are we here and who are you? But yeah, beyond that, it was the arguments were less than an hour, and he did such an excellent job at kind of delineating the real issues. And you heard him ask, like, he had kind of an attitude of, this doesn't seem right, within about 5 minutes.
Mm-hmm.
And then he asked what I thought were the right process questions. And, other than kind of some bloviating, you're right, they didn't have a direct response to the process and to the appeal process. And then when they asked, he asked, I think, about the rules and regs, and they're like, well, there really aren't any. Yeah. So he's like, well, what do you fall back on if you don't have rules and regs in place? Which we were all kind of like, I've been asking about rules and regs forever, because I'm like, we're sitting on inventories that have been, past inspection. And I'm like, well, are these products going to be good for a while? Are we going to have a sundown or a sunset provision in this? And no answers. And I too think in this process, you had people that are literally getting personal meetings with the OCM about this. And then other people that can't even get an email responded to. So what type of polarity do we have with the office and the assistance from the office?
Yeah, I think that's such a great point. And it's all alleged in filings. But if proven out to be true, in one of the filings is noted that there was someone who received a denial, who reached out to Charlene, who would then forward on to Max, and suddenly that denial was reversed. And like I said, that's been alleged in a filing, but if that proves out to be true and substantiated, I think that's pretty damning for the entire structure that's running OCM right now.
And then, in my opinion, guys, that's the tip of the iceberg. Early on, I know you guys have seen me mention a list, priority list, an advocates list, and I've talked to the OCM. I've literally said, this is going to get you in trouble. You're going to have secret meetings, you're going to have private meetings with folks that are going to be on or getting licenses, and they're going to wonder how these people literally went, had a straight track to a license, and other people are literally fighting for scraps or fighting to keep their business. And those things, went to legislators, they went to the OCM, they went to several stakeholders, and it didn't seem to be something they would even acknowledge. And I'm like, well, these came from you. I got data requests. I spoke to Erin Dupree on her initial contact priority list, and it was shocking. I mean, it was shocking. And I even testified at one point last year. I know I caught some heat for it, but when a new director is required to make contacts with lobbyists before anybody else, what does that say about our internals?
Yeah.
And I'm not cool with that. And I don't think, many social equity applicants, many regular market folks are not cool with that. And you guys know, since 2014, we've been catering to a certain set of lobbyists, and they're still the same lobbyists.
Yeah.
And they're still in the back room. And what happens? I got interviewed from a gentleman from Australia about my concerns about Minnesota, and he covers cannabis law all across the country. And I'm like, God, maybe I'm not a conspiracy theorist. Maybe I'm not crazy. Maybe I'm not, just a jerk.
No,
I'm just
I
concerned about where things are going here.
Yeah, it was interesting to hear one of the attorneys for Hundo et al., and I quoted it because I thought it was such an interesting phrase. There appears to be a scheme by OCM that nobody else is in on. And I think that continual use of the word scheme, man, it rings really in an uncomfortable light with everything that has come out over the last couple of days. And I try to be that person, and we've disagreed in the past very respectfully, but about
Yes.
I want to consider that these people are trying to do their best. But I think it's clear that in this process, we just didn't get the best that we deserve.
And that's where I think, this squarely lands on the shoulders of our legislators, the OMC, and the governor's office. And I'm not going to move off that, because I know what I've seen, and I think people are seeing it now, that this organization of this whole thing could have been done differently from the start. It could have been transparent from the start. But, you have these inside influences with lobbyists and lobbying strategists and people that have existing businesses. But yet you have leadership that has no cannabis experience. And so what they lend themselves to do is they kind of use these people as the backup experts, and all of their information comes from this small group, and the stakeholder input ends up being fake. And they ask all these questions. I fall back to when the lottery was first introduced, the amendment, and I listened to stakeholder after stakeholder in the equity side say, this is not for us. This is not for us. And they were 100% right. And instead, what did legislators? Well, we'll take that under advisement, and they smashed it through anyway. And I remember a gal coming up to me, I won't say the name, but she was like, well, I know what vetted means. And she knew, if that wasn't just the writing on the wall, like, she knew vetted was going to toss legitimate people out of the market. And if you really look at it, think of the emerging farmer redefining. Just that aspect alone of these amendments. I followed up after I had a meeting with Marone Melican about this. And she said, well, why didn't you try and qualify under the emerging farmer? I'm like, well, have you ever met a farmer that's got $100,000 gross revenue? They might have $1 million loss, and they still wouldn't qualify because it's gross revenue. And I'm sitting there like, there's not one farmer that I know that would qualify. And so she said, oh, I'll follow up and get you. I think some people qualified, and it was less than 1%. Only because of the redefinition or the redefining of emerging farmer. And my follow-up question was, well, where did that language come from? And who decided that that was some really important language to be changed to exclude 99 or over 99% of farmers? It does beg, it does make you develop some questions and wonder, like, where is this bill language coming from? And I think if we all demanded source language, where did the amendment come from? Who handed it over? I think we would learn a lot.
Yeah,
and we could follow that down with many amendments for sure.
So just to play devil's advocate for a little bit, I'd love to hear your thoughts on what you might say to someone who would say, this entire vetting process, well, yes, a lot of people were removed from it. It removed a lot of people that we don't want as part of our system. There was a lot of people that were cheating the rules. What might you say to someone who sort of supports the actions that OCM took?
I think we do need to vet the abuse, right? But what are we doing? Like, to me, I think there's a way to do that without throwing the baby out with the bathwater, right? The kind of a blanket, well, if you think of the vetting, it didn't work because it excluded folks that probably shouldn't have been removed from the lottery, and it probably removed a certain number of people that obviously shouldn't. But did you hear that out of the total number, so what was it, 1,800 remaining in the group before the
cut-in? Yeah.
Right. I think there was only 300 what do you call it? Deficiency notices.
Yeah, I found that.
And go ahead.
Oh, no, I found it very interesting that of the applications cut, only a third of them received any sort of notice. And we've been calling it deficiency notices this whole time, as argued by the attorney for the OCM today. That was actually a request for additional information, which is legally distinct. And actually, they don't have to send any deficiency notices, which is just so jarringly different than what we've been hearing from the state for months.
Correct. It was a very kind of about face, right? It really were the words they said to you didn't really, stick to paper.
Yeah.
And my worries are we've got an elongated process for folks. People have to hang on to leases and properties, and like, I'm still I'm making payments on a farm that I bought in 23, and it's I'm still growing hemp, but that's not going to pay for the farm. But I do think that, so everybody that's been fighting for this and waiting in line is still fighting for it and waiting in line. And what is the solution going forward? You either revamp the lottery, which I think it's got a horrible track record already, or you find an alternative. What's the alternative on an early start? Charlene has said, oh, well, maybe medical and the tribes can kind of be this bridge until the industry stands up. And I think that might be I don't think it's a fair way to go about it. But was that in the plan the whole time? If this failed, like, we have a backup plan and we're giving an advantage to tribal members, which I really don't have a problem with as long as they're growing their own. But the current situation, it really isn't that, I don't think. And in the medical, we've been giving these guys the advantages since 2014 and looking the other way, no enforcement. And I've learned that, there's 100% enforcement on the hemp side, 0% on the medical side. We're one of the only states with never a product recall or an enforcement action. It's hard to square that when you're fighting every day.
Yeah, we both know of things that have happened on the medical side of the industry that if it was a an active regulatory agency, like they're claiming that they are when they look at businesses like Zaza and others, that they're saying this is our required role. I wonder where they were. And I get it wasn't the OCM before, but the regulatory body has been in existence since 2014. And
it certainly has. And that regulatory body wasn't completely scrapped. It was basically added on to. So I thought, well, maybe that they'll clean that side of it up, and it isn't. And I'll relate that to some of the lobbying that's been done. It's kind of a hands-off, leave them alone, let them operate how they operate, as long as they don't hit the news, right? And but too, I also look back at where we are at today, and we've had so much ignorance of the press. They've completely ignored some major poignant issues. And what are they going to say now? These things, it's the press, it's the journalists that should have been chasing some of these issues down. And whether that's exposing or a documentary or any type of light shedding on these issues would have been great. But instead you get these kind of vanilla, very kind of monotone articles that really don't have a ton of information.
yeah.
And it's like, no, we need to, we got to critique this stuff, and we've got to, really open things up and dig in. And I just don't think there was a flavor for that, because we want cannabis, right? We want to get it pushed through. We learned that the first time with the first passage, but, the scrutiny wasn't applied early on. And I think when it was, we got some heat for some questions. There's some other businesses that got some extreme heat for, talking out or speaking out about this. And not that we were forecasting this, but we knew there was some internal problems and maybe a little too cozy relationships that things were probably going to blow up,
Yeah, no, I think that's a good point. And it was, I don't want to name and shame any journalist specifically, but it was interesting seeing a news article come out after the court had ruled against the state, and the byline still was a quote from the state's attorney. And it's like, no, I'm so sorry. Actually, the court ruled in the opposite direction. Like, if anything, you should be quoting the judge or the defense or something. And I think we're seeing the, and again, I don't want to sound like the conspiracy theorist, but the harms of having close relationships between the people that make the decision and the people that report on those decisions. And it's tough to be the journalist, I imagine, in the place to say, hey, I'm going to report and it's going to make you look bad, but it's because you messed up.
Right.
Do your job.
And that's I think the thing is a ton of people, I got some calls like, you were right. And I'm like, really, it's not, that wasn't the point. And the point is to avoid this chaos and avoid this type of situation where, you're hurting people right now. And I'm not saying you, but the state is hurting some people, including myself, including anyone that's in this business trying to move forward, and really not giving us an opportunity to grow. Beverages were great, on the hemp side, but they're like for a medium to small business, the margins are terrible, right? So, oh, you guys are selling a ton of beverages. Hey, I love selling beverages, but I make $1, and, and I think where, and then they cut down our potency, which I'm fine with regulating potency and safety, absolutely. But when you put us behind other states, we're at 5 milligrams. There's not a, I think we're competing with Iowa at 4, but, everywhere else, when it's online and we're competing with online, we really don't have any,
yeah,
other than, my SEC products have my hemp. That's great. But, if I see 5 milligrams versus 25 milligrams at the same price, I'm probably hitting a 25er.
Absolutely. Well, and it's funny to live in a time when, between us and Wisconsin, we're the legal state. But if you wanted to buy like 27% THC flower outside of a tribal business, you go to Wisconsin to do that. And it's the,
right.
duality of the hemp and adult use laws has led to this very strange dynamic between the two.
I do see this as I see some opportunities with tribes, like if they would be kind of willing to jump out and work with us, smaller businesses. I think that would be kind of a neat thing. But I don't know if there's a will to do that. They kind of like to do their own thing, so I understand that. But at some point, I'm kind of like, well, if the state can't run it right, maybe we work with the tribes and run it right.
Fair.
And it would actually be kind of fun.
Yeah, I think especially depending upon the community, some are much more regulatorily friendly than we've seen here in Minnesota.
Yeah, and really, if that wouldn't be the case, I'm such a proponent of regulating this like tobacco or alcohol. It's not a toxin. And to me, that's the start. Look at that. That's the main point for me of cannabis is that, yeah, I'm not taking a toxin. I'm taking a plant that is good for me, that supports my body and my mind. And I feel like we could find a safe way to do that and really, work on bringing that legacy market into the light and feeling like they could operate a small business without kind of these regulatory hurdles that, really could hurt your business forever or hurt your livelihood forever.
I think we're seeing the best example of that rolling out in front of us. It's got a lot of people ready to start businesses, and we're just sort of waiting for the state to get their stuff in line.
Exactly. And I think too, if you really looked at the purpose of this whole program was right to develop a craft industry and to get social equity people on a solid footing, right, early on, and then to bring the legacy market into the regulated market. But I can tell you that most of the people I've talked to want nothing to do with this right now. And I don't blame them because, either just stay on the down low and do what you're doing or get into this chaotic mess and lose a ton of money along the way. What would you do?
Probably just keep doing the same thing I've been doing for decades.
And that's the thing you could, people ask me, it'd be great to have a dispensary. It's hard to find. And I'm like, not really.
Yeah. Just gotta know the right people.
Right. Well, and that's a matter of 4.5 minutes on the internet, right?
Exactly.
And I think we could do a much better job if we simplified this dramatically.
Well, that feels like a really good place to leave it. Jeff, thank you so much for taking time out of your day to chat with us about this. I'm excited.
Same. And I really appreciate too, Tanner, your guys' focus on, kind of getting this to a different level. And in what I mean is the scrutiny needs to be placed on the agency. And if it's not, we're going to keep kind of going through these fiascos. And really, what we're doing is we're hurting the consumer and we're hurting these small businesses that, keep sitting on their hands.
Yeah, I could not agree more. I'm so looking forward to a day when we have stores open and operating businesses. And I hope that the fun of government regulation doesn't keep that too long from us.
Absolutely. Well, I sure appreciate the time.
Yeah, thank you so much. Have a good rest of your Monday.
You too. Take care.
Thanks again.
Bye-bye.
So there you have it. We wanted to end today by reading the official statement that the Office of Cannabis Management issued in the hours following the court decision. They said, "While we are disappointed by the decision to prevent OCM from moving forward with a licensed preapproval lottery tomorrow, we stand by the process used to review applications. Minnesota's approach has always aimed to protect the integrity of a social equity license, and the rigorous review also allowed us to identify and prevent bad actors from entering the system. State statutes set high standards for applicants to successfully complete applications, while also filtering out those with malicious intent. We remain committed to launching an equitable, sustainable, and responsible adult use cannabis marketplace in Minnesota. This is a story that will continue to evolve, and we'll continue to break it down right here on Northern Lights Podcast. Thank you all for listening today, and make sure to tune into your feeds next week because we'll be back with even more stories. Thank you all.